Hi, good morning. Hi, this is David here, planning consultant, ex-planning lawyer as well. I thought I'd post a quick video to you about something I'm handling at the moment for clients might be very useful to you, might be interesting to know. It's about HMOs and about the difference between HMOs and self-contained accommodation. So it's quite typical sometimes that you get a house and the house is then divided into smaller units and they might be self-contained. So each of those studios might have its own bathroom, it might have its own kitchen, and therefore behind the door to each of those studios they've got all the amenities for modern living. So you've got all the cooking, washing, cleaning, all the apparatus there. So that's self-contained, and when you do that, that makes each of those units in planning terms a class C3 use. So if you have a house and you divide it into 6 self-contained studio apartments, or 8 or 9, then each of those becomes a C3 flat or studio. And planning departments often have a problem with this because sometimes those units are far too small to comply with nationally described standards. And a lot of developers and investors, they don't realise this. They might have been advised by somebody who then only got in touch with the housing officer because they thought they were doing an HMO and therefore they would be able to get it licensed. And the housing officer comes back and says, actually, the units are all fine as far as housing goes. But that's because the housing officers only look at it in terms of the Housing Act. They don't look at it in planning terms. And it's very important to understand the distinction. So when you're looking at planning, it's very different to licensing. So make sure that before you do those works, you have that conversation with the planning department as well as with the housing department. And if you don't speak to the planning department first, at least speak to a planning consultant, because it's quite common in my experience that a lot of architects and builders, they don't realise this distinction, and so the works get done, it then gets reported somehow to a planning enforcement officer. They come down on site and they say you've got to rip out all the kitchens, you've got to do a whole load of works to it, or they might serve you with an enforcement notice, and it can cost you tens of thousands of pounds to undo the works and then put the right works in place instead. So it's very, very important when you're doing HMOs or thinking of doing small studio apartments in your property that you understand the distinction between speaking to housing officers for licensing and speaking to planning officers for planning. Thanks very much. Have a great day.